the state of Florida is now in session. The Honorable F. Graham Wallace, Judge, presiding. All persons having business before this court drawn near, give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I've already been introduced. I want to introduce also on the panel joining me from Duval County, Judge Harvey J. to my right and your left, and to my left and your right, Judge John Harris from Brevard County. We have 2 cases on the docket. See, we don't have any lawyers at the table for either case. So the first case is Silverthorne Hernando Homeowners Association versus Hernando County Silverthorne Associates and Acorn to Oak Tree Investments, LLC. So the parties can go ahead and I am going to assume, is it Ms. Cox? Is that correct?
Yes, sir.
I will assume, Ms. Cox, that you would like 5 minutes of rebuttal unless you tell me otherwise. And just ask that the parties please make sure that anybody in the courtroom as well, silence any device you have that may make a sound during the oral argument so it doesn't disrupt the attorneys in making their presentation. And with that, Ms. Cox, you may proceed.
Good late morning.
Late morning.
I represent the Silverthorne Homeowners Association. And to give you the background of this case, and I know you've read the briefs, but before the development of the golf course and the 801 residents that constitute the Silverthorne community in Hernando County, the developer installed walls and perimeter fencing around the entirety of the development.
Ms. Cox, for the record, I looked throughout the entire record and I can find no visual depiction, plan that depicts specifically the fence and the existence of the fence on the property. There wasn't anything like that put into the record, is that correct?
No, the visual depiction of the community is an illustration that is at 2627 through 2629. It is not a photo, and it does not depict the fence itself. What it depicts is the community and the boundaries of the community, and then the plats also commit. But there, as far as a picture of what the fence looks like, there isn't a photograph of the fence.
And I'm not talking about a photo. I'm talking about a plat or a plan that shows the fence. I think there are portions of, based upon the allegations you have made, there are portions of the fence that is around or it demarcates a line between a residence and the golf course, but then there are also sections where there are no homes that depict no fence, correct?
Okay, yes, there are, all the plats for the community are in evidence, or in the record rather. And in the record, they appear at, beginning at 2366. If you look at those plats, you will see the easement that was created for fencing on the perimeter boundary of the community. But what's not at issue here is that on the eastern boundary, no easement was created for the perimeter fence on a portion of the golf course property. That is not true with respect to all of the golf course property, because some of the golf course fairways, because like your typical golf course community, the residences are built within the holes. So many people have a view of the golf course in their backyard. So some of the holes are on the boundary and have the perimeter fence installed, and an easement is reflected for that. But on the eastern portion of this community, there is a section where no fencing easement exists, but this perimeter fence, which has been described as a substantial cyclone fence, has existed since 1994. And that's can be found in the testimony, the affidavit testimony of David Felice and Frederick Burkaw, who were both involved in the development of the community.
Let me ask you about, before we get too far,
Sure.
the Declaration of Covenants and Restrictions, and particularly Article 12, Paragraph A. What does that language mean? And specific, I'm talking about the portion that the judge left out or replaced with the ellipses in the final, in his ruling, and those portions of lots for monitoring security systems, et cetera.
Well, that renders that paragraph or that thing at a minimum ambiguous, because it suggests that perhaps the utility easements are for the purposes of monitoring, because you have for monitoring. It's not a well written provision, because it does have a qualifying clause.
Are there lots, or was there anything presented below? Are there existing lots that are currently used for monitoring security systems and utility facilities?
No.
There are no lots that are set aside for that, so this really does not make any sense.
It doesn't make any sense based on the record. I'm unaware of any section, anything in the record that would show that.
And in line with Judge Harris's question, what does it mean? What's the HOA's position on what it means? I mean, putting the words in the ellipses, I mean, what does it mean?
It seems to mean that the utility easement is restricted to the purpose of monitoring the utility facilities. That seems to be what it means. It's not a picture of clarity.
But if that's the case, then doesn't that render useless the use of the word installation and maintenance? If it's just for monitoring.
Installation and maintenance could be monitoring facilities. You know, so it's a hash of a paragraph, no question about it. So, so at a minimum, you know, it's ambiguous.
If I can point you to page, I think it's page 18 of your brief, and specifically on that page, you talk about the phrase for monitoring security systems and utility facilities and distribution lines, and you say that means that the easement is only for monitoring security systems, utilities, facilities, and allowing the installation, maintenance, repair, replacement, and use of such systems, facilities, and lines within the common areas. What rule of construction or grammar leads you to that conclusion based upon your reading of that? Can you explain to me how you get there?
In order to give that misplaced, what seems to be misplaced clause of for monitoring security systems and utility facilities and distribution lines, that's the only interpretation that I could come up that made it all make sense. So, because that seems to be a qualifier. But as far as that issue, if we're talking about the easements, then the easements, regardless of whether they're ambiguous or not ambiguous, they are easements appurtenant that cannot be severed and transferred or assigned separate from the dominant estate. So
But isn't that specifically what Article 12, I mean, at least in writing, says? Transferable, alienable, and perpetual rights and easements. And it says, for the benefit of the developer, its successor, and assigns. So that speaks, your argument right there speaks directly contrary to the language of this particular Article 12, correct?
But Article 12 is ambiguous, I think. And I think that if you look at Article 12 within the context when you're construing Article 12, you have to look at the entirety of the declaration, and the declaration reflects here an unambiguous intention that this be developed as a community where the association had control over access and control over the roads, and did not envision, incorporating other areas into the community.
If you take the Article 12 in its entirety, and obviously the intent in creating the actual declaration includes anticipation of needing services, specifically utility services. Isn't a reasonable interpretation of the phrase that I was just talking about that was in your brief is that this just merely modifies, when you read into that entire section, Article 12A, the easement holder can access to perform work. In other words, the easement holder can access common areas, but it can only access those parts of residential lots where they are monitoring security systems, utility facilities, and distribution lines. So specifically, I believe, would it be reasonable, or a reasonable interpretation of that, it's talking about where they connect to the actual utility service from the county and the connection into the common areas of the community. We're not talking about everything, we're just talking about, and specifically this would incorporate the installation and maintenance of those two connection lines in the community. Is that a reasonable interpretation?
Yes.
Okay.
So, go ahead.
Oh, no, I would just say, but to the extent that we are debating what a reasonable interpretation is, the section warrants, at a minimum, looking at the rest of the declaration to determine intent and parole evidence as well. This is not a community that was ever, there was no intention that the facilities by the developer be used to further the development of another community, which is exactly what's being done, or is attempted to be done here. There's an easement appurtenant that is that Acorn, which is a stranger to this community, is trying to exploit for the development of their property, which we don't believe that the law supports the use of this easement in that fashion.
So is it your position as to this purported ambiguity that it's a patent ambiguity or a latent ambiguity?
Patent. I think it's patent.
And your understanding of that is it's internally inconsistent as opposed to the way it's applied is creating the ambiguity.
Yes. And if I can turn to the perimeter fence issue, the perimeter fence is, we wouldn't be here on that issue if there was in fact an easement, but we believe that the law of implied easements establishes the association's right to exercise authority and control over that perimeter fence. That perimeter fence was is, if you look at the declaration, which the declaration was filed before the plats and is referred to in each and every plat, and it talks about common elements as fences and common improvements as improvements installed by the developer for the protection of the community. This is a continuous fence, and the community includes the golf course. So the duly recorded declaration created the fence as a common improvement. Now, the trial court found that the association had no authority over the perimeter fence, but that's belied by both the declaration and the practices for 40 years, where the association has maintained and exercised authority over the perimeter fence and directed the golf course owner. So at a minimum, there's a factual dispute on that issue. This is a case that came before the trial court on cross motions for summary judgment, and I'm not re-arguing my motion for summary judgment, but there is no record evidence that the golf course owner owns the perimeter fence. He didn't even say that in an affidavit. The association put in a lot of record evidence, including the developer and the president, the initial president of the association, to say that that perimeter fence was dedicated to the association. And it's been there since the beginning, before anything was built. So it is unquestionably something that was installed by the developer for the protection of the community. It is a common improvement, and under these circumstances, the law of implied easements allows an easement to be applied for the portion where the plat did not provide for a fencing easement. So I will, if you don't have any other questions, I'm getting close to 5 minutes.
Okay. You would like to reserve, is that correct?
Yes.
Okay. Counsel, you may proceed.
Would you like to hear from Acorn first, Your Honor?
Sure. I'll let you all divide up your time, however you would like to do that.
We submitted a filing that I'll be taking 15 minutes, and counsel for Silverthorne Associates will be taking 5 minutes.
Okay, I'll let you all monitor that, and, okay.
Thank you, Your Honor, and may it please the court. My name is Nathaniel G. Fell, Carlton Fields, and I represent defendant Appali Acorn to Oak Tree Investments, which I will call Acorn for short. An easement should be given its plain meaning. That is black letter law, and no party here contests it. That well-established principle is sufficient to resolve this appeal as to Acorn. Plaintiff appellant, the HOA, argues that the easements at issue are not transferable, despite the fact that the first sentence of those easements describes them as transferable and alienable. The HOA also argues that the easements at issue do not permit installation of new utility hookups and are instead limited to monitoring of existing utility infrastructure, despite the fact that the second sentence of the easements at issue features the word installation. Neither of these arguments about the easements at issue can be squared with their plain meaning. Acorn made those points about the plain meaning of the easements at issue in its answer brief, yet you will search the reply brief in vain for any rejoinder to those points, much less a compelling one. Indeed, the HOA wants to talk about anything but the plain meaning of the easements at issue, instead making one new argument for the first time in the initial brief and developing a second new argument for the first time in the reply brief. But despite the HOA's avoidance of the plain meaning of the easements at issue, that plain meaning controls. Because the trial court correctly understood the plain meaning of the easements at issue, this court should affirm the trial court's entry of final summary judgment in favor of Acorn as to count 1 of the operative complaint.
Why did the trial court utilize ellipses in reciting the reasons for the ruling and citing to the specific declaration article?
Your Honor, I believe that's because that portion of Article 12 is simply not relevant to the dispute between the HOA and Acorn, because no one is arguing about where the activities that are permitted by Article 12 can take place. everyone is arguing about what activities can take place, and the portion that the trial court quoted is the portion that answers that question. As you construed it, Judge Wallace, it permits installation. That is right there in the first sentence. And then the portion that the trial court omitted describes where the various permitted activities can take place. And it's simply there to give the homeowners the reassurance that someone can't just show up anywhere on their lot and say, well, I'm here to deal with the utilities, right? The utilities activities are restricted by that clause to the common areas and to certain portions of the lots. And since that's not at issue between the parties, that's why it seems
There's
perfectly...
certain portions of the lots. What do you mean? Well, what does for monitoring security systems mean?
I understand that to mean that there are portions of lots that you might need to access to deal with the utilities, and there are portions of lots that you would not need to access to deal with the utilities, and that the easement is limited to the portions of the utilities that you might need to access, or the portions of the lots that you might need to access to deal with the utilities. That's the construction of that phrase that I have and that we provide in the answer brief. And we submit is the plain meaning of Article 12. I also want to note, Your Honors, that there are two issues as to the meaning of the easement. There's this issue that's about the scope of the easement. What can you do under the easement? So if the easement can be assigned to Acorn, what can Acorn do with it? And there's a second separate issue as to the meaning of the easement, which is, can it be assigned? And I think it's helpful to keep those two separate. Judge Wallace, I think the first sentence of the easement that you quoted to counsel on the other side is entirely dispositive of the assignability issue. The language there makes clear that the easements are transferable, that they're alienable, that they're for the benefit of the developer and its successors and assigns. And so really, the HOA is not even engaging on the assignability question. The question that it's taking up is the scope of the easement. Let's say Acorn has rightly been assigned the easement. They, in effect, seem to be saying, what can it do with it? And I submit, beyond all of the textual arguments that have been made, there's just the fact that if you step back and think about it from a common sense perspective, it doesn't make sense that this easement would be limited to monitoring utilities. What use is that to the golf course property? Why would it have asked for that? Why would a lawyer have sat down and wrote this, taken the time and the money to do that? It doesn't serve any function for the golf course to just be able to monitor utilities. It would need to be able to engage in additional activities, potentially. Let's say something goes wrong with the utilities.
Why wouldn't that create an ambiguity?
Well, because there's only one reasonable way to construe that clause, Your Honor, and that's for reasons of both text and for practicality that I'm currently describing. Again, take the situation where something goes wrong with the utilities and it needs to be maintained, repaired in some way. Could the HOA argue, well, you can't do that. You just get to monitor them. You monitored, you saw something went wrong, too bad, right? That just does not make sense as a construction of this on a practical level, not to mention that textually, clearly installation and the other activities that are enumerated in the first clause have to be permitted. That is exactly what the first clause says, and the only reasonable way to construe that first clause in Article 12,
Well,
the first
what
sentence.
rule of construction are you using to get to that interpretation?
So I don't think that, candidly, you need any particular rules of construction, canons, grammar. I think it's just a matter of reading the sentence and seeing what modifies what. And counsel on the other side agrees that that phrase about monitoring is a part of a qualifying phrase. And the question is, what is it qualifying? And the only way that we think to understand it is there's a range of activities that are outlined in the first clause that you're permitted to engage in per the easement, and then that describes where you can do them. That's what it qualifies the first clause.
And are you saying that where you can do that is limited to only the common areas?
The common areas and then certain portions of lots.
Okay, all right. And so in that phrase, replacement and use within the common areas, do you believe that that portion of the sentence is rendered stronger or weaker to your position if you put a comma in after use and before within?
So that might make the sentence clearer. I would have to think about that candidly, Your Honor, but it would be a matter of making something that's already clear even clearer, I think, as opposed to resolving an ambiguity. There is no ambiguity here, we submit, as to the scope of the easement or as to its assignability. I have some other points to make, Your Honor, but before I do, I should inquire, does the court want me to address the jurisdictional issue? Or if the court does not have any questions about that, I'll just move on to my other points.
We'd like to hear your position on the jurisdiction issue. You can make it brief, though.
So Acorn believes that the order on appeal is an appealable final order, and that the most instructive case on that is one that's cited by the court in its recent order notifying the parties to be prepared to address this issue, namely the Touchton case from the second DCA. And Touchton is a declaratory judgment case where the second DCA found that the trial court, quote, essentially nestled a declaratory judgment within an order granting a motion to dismiss, end quote, and that's at 316 Southern 3rd at 395. And because of that, the second DCA found that the order on appeal there was an appealable final order. We submit that this case is just like that, but in the summary judgment context. In other words, that the trial court here, quote, essentially nestled a declaratory judgment within, end quote, a summary judgment order. And specifically, the court did that in the last page of the order on appeal, which is page 2775 of the record. There are 7 numbered paragraphs on that page. And paragraph 4 is a declaration regarding the relief requested by the HOA in count 1 of the operative complaint. And paragraphs 6 and 7 are a declaration regarding the relief requested by the HOA in count 2 of the operative complaint. So those paragraphs taken together constitute the declaratory judgment of the trial court, and they ended the judicial labor in this case. It's also worth noting that the order on appeal is entitled An Order on Motions for Summary Judgment and Final Judgment. That was not the title of the cross motions for summary judgment that were submitted. The and final judgment was added by the court as words of finality. And the last point I would make as to jurisdiction, Your Honor, is that there are 3 cases cited in the trial court's order to find that a declaratory judgment was an appealable final order. One finds that it was not. That case, Mid-Continent Casualty from the 3rd District, we think is clearly distinguishable. It's distinguishable because there the plaintiff was seeking 2 forms of declaratory relief, one being that an insurance company had a duty to defend the plaintiff, and the other being that it had a duty to indemnify the plaintiff. And the order on appeal there only provided declaratory judgment as to the duty to defend, not the duty to indemnify. Whereas here, all of the declaratory relief that was sought by the plaintiff, by the HOA, was addressed by the order on appeal. And that, again, is why it constitutes an appealable final order. Give me one moment. Excuse me, Your Honors. And that is our position as to the jurisdictional issue. The final note that I should add on that is that if the court has real doubt as to whether the order on appeal is an appealable final order, we would ask that the court exercise the discretion provided to it by Florida Rule of Appellate Procedure 9.110L, which empowers this court to grant the parties additional time to obtain a final order from the lower tribunal. So the court could relinquish jurisdiction to the trial court for, say, 15 or 30 days, for the court to enter a truly final judgment if this court concludes that the order on appeal is not a truly final judgment. And I will note that that seems to be the practice of this court. That's been done at least 12 times in the past 20 years by this court. And if it would be helpful to the court, I can provide those citations in a supplemental brief. As to the point that the HOA makes about an easement appurtenant being transferred apart from the dominant estate, I would make a couple of points. The first is that this argument was not made to the trial court, and it was actually not made to this court in the initial brief. It was really made first at any length in the reply brief. There is one paragraph buried on page 25 of the initial brief that seems to make this point, but it's not really elaborated until the reply brief. And so for that reason, we think that this argument should not be considered, along with the other new arguments that the HOA has made on appeal. But the second point that we would make is that the HOA's description of the legal principle at issue here, we think is critically incomplete. There's a case, 7 Kings, that discusses this principle, and it says that an easement appurtenant cannot be transferred apart from the dominant parcel absent, quote, a clear intent to the contrary in the instrument creating the easement. That proviso was never acknowledged by the HOA. It appears at 364 Southern 3rd at 1115, and we think is exactly this case. So there are 2 reasons why that argument about the easement appurtenant not being transferred apart from the dominant parcel does not work here, because it is the clear intent of the easement that it be transferable in that way, and that's shown by the fact that it's granted to the developer and its successors and assigns, as you noted, Judge Wallace, and by the additional language in that sentence noting that the easements are transferable and alienable. So that principle accounts for the fact that when the easement is clear, that an easement can be transferred apart from the dominant parcel, even an easement appurtenant. And again, that speaks to the plain meaning that we think that the HOA has studiously avoided.
Why doesn't the HOA get an implied easement on the fence?
Counsel for the other defendant is going to answer that. And that's an important point, Your Honor. That's not relief that's sought against Acorn. That's count 2 of the operative complaint. Acorn is only implicated by count 1 of the operative complaint, and so takes no position on that issue. Will not be speaking to that issue. Unless the court has any other questions, I will rest on the answer brief. Thank you, Your Honors.
Good morning, Your Honors. My name is Daryl Johnston with Johnston Law Group. I represent Silverthorne Associates, LLC, who is the party in count 2, that is the appellee. Good morning. Your Honors, the big issue here is we have somebody that's trying to establish an implied easement for a fence over property that they don't own. The argument that there was a 10-foot reservation along the Silverthorne development where the developer could have put a fence but did not, the fence was put on the golf course property. The affidavit of Jerry Hurd attached to the summary judgment, as well as the admissions and concessions at the hearing at the summary judgment. The fence is owned by Silverthorne Associates. A portion of that fence is clearly next to the Silverthorne development. But the golf course itself is fenced in and goes beyond the Silverthorne development. In fact, it's adjacent to the Acorn to Oak Tree development that's coming in and some other vacant land. That fence is owned by Silverthorne Associates. They should be able to control it. There is no basis in law that I can find or understand that's going to allow somebody that's not even adjacent to it to establish an easement for a personal property they don't own and on real property that they don't own. There were many things that could have been done by the developer before they sold the golf course originally to U.S. Golf and then to Silverthorne Associates back in 2001. Those things could have been, reserving that property for themselves, not conveying out the property that included the fence. It could have been you could have put a spike strip of some sort in there. There could have been some other things that the developer could have done if the intent truly was to make sure nobody could ever cross that fence when the golf course was going to be owned by someone else. As the court may know, golf courses during the 80s and 90s, and probably before, didn't require necessarily membership for your golf course. And so the developer held that golf course, sold it off to somebody, didn't convey it to the HOA.
Mr. Johnson, what are the elements of an implied easement that the HOA failed to prove as support for your position that they're not entitled to this implied easement?
I think what they failed to prove for the implied easement is the, excuse me, Your Honor, I'm sorry, I'm trying to get to my point. That there is a property to be benefited. The HOA property is not benefited by the adjacent fence to property that's not connected to the HOA. That it was an intention for this fence to be used for the benefited property. There's just no language, oral or in writing, that establishes an implied easement over my client's property, particularly the part of the property that's not even adjacent to the Silverthorne development. And typically, Your Honors, the implied easement typically applies when there is a road that's going to provide access to someone. We're not dealing with that. There's a reservation of access and utilities for the Silverthorne property through part of the Silverthorne development. There's just nothing that establishes that an implied, certainly not express easement, not an implied, would apply. The only other thing I would add, Your Honors, is that the HOA can still put a fence along its boundary. It has 10 feet behind each of its homes that it has the ability to put a fence if it wants to provide security, but it should not have the ability to create magically an easement over property it doesn't own for personal property that it doesn't own. If you have any other questions, I'm happy to answer, but thank you.
Thank you. You have about 5.5 minutes.
So an easement is simply the right to use another property for a specified purpose. So the fact that the golf course is not owned by the association, of course not, or we wouldn't be talking about an easement. Mr. Johnson has said that the property that we're talking about is not connected to HOA property, but it's all, and sometimes I get a little bit confused about what he's saying when he says it's not adjacent to the Silverthorne development, it's not connected to HOA property. What we are talking about is a fence that surrounds the entirety of the community. The 801 homes, the recreational facilities that were built by the developer, and this 18-hole golf course with a country club. So it goes around the perimeter boundary, and if you look at that, at the illustration of the community, you can see the community depicted, and then the plats show you. So the point is that if you remove that fence, you open up the back of the community, and this is a community that was specifically designed to have a gated, guardhouse attended entrance where the public was checked in and only certain access was granted to the community for use of the country club and golf course, and the HOA's given authority to do that. This is exactly a type of situation where an implied easement is appropriate because there was separation of title from a common owner. The developer owned everything when he built the fence, and then he sold homes, transferred property to the HOA, and then ultimately sold the golf course in 1998. There was an apparent invisible use before the separation took place. The golf course owner, the present one, describes it as a substantial cyclone fence. And the use was continued long enough to show it was meant to be permanent. Well, it's been there for approximately 40 years, and it's reasonably necessary for the use and benefit of the dominant estate. There is a fence around on the easement, on the plats, and behind the houses and along the fairways, and on this one section where there was no easement. So sometimes I'm not really sure what Mr. Johnson is saying when he says it's not adjacent to HOA property. It's all part and parcel of the same community and part of a continuous fence that goes around that was installed by the developer. There isn't any meaningful way for the HOA to correct the issue by installing its own fence because of the way that the golf course is, that it goes all through the community. So if you can come in through the back of the golf course owner has easements to get across roads from hole to hole. So, and as far as the suggestion that implied easements are only appropriate for access, in Croma versus Norton, which we cited in our brief, that was the use of land for a sewer line. And in Hurlinger versus Stelzer, which is also cited in our brief, that was use of land as a recreation area. The doctrine of implied easements is just for any use that benefits the dominant estate, not specifically limited to access.
Ms. Cox, would you address briefly the statement from counsel for the appellee for Acorn, specifically that the omission of the words, it's those portions of lots and monitoring security systems, which was not included in the order that's on appeal, that is irrelevant to the discussion on this appeal about the utility, attaching or installing utility.
I'm sorry, but it's irrelevant.
The omission of the words from the trial court is irrelevant to the discussion here, which involves installation of utilities attachments. Would you agree with that?
You know, that is such a complex paragraph that I'd have to think about because it's...
Well, we're not talking about monitoring security systems. You would agree?
Yes, but I think that you can read the for monitoring security systems as establishing the purpose of that easement. Monitoring security systems and facilities. Hang on, let me go look at it. Yeah. So, I mean, it's, as I said, it's a dense and complicated paragraph, and so I just am not sure that I agree.
Okay, and your time is expired, so.
Okay, thank you.
Thank you, ma'am.